Hello, everybody. Welcome to another edition of CNF Talks. And today I have Sarah Thomas, who's a partner within Global Investigations at Adelshore Goddard, who's come to speak to us today. She is going to be talking at the Financial Services Investigations and Enforcement Summit at America Square Conference Centre in London on the 26th of June. Sarah, welcome.
Thanks, Maurice. It's great to be here. Great to talk to you.
Very good to have you with us. Let's turn to our first question. The House of Lords Financial Services Regulation Committee recently wrote to the FCA expressing their concerns about the proposals to name and shame firms subject to an investigation, arguing that it could lead to unwarranted impact on blameless firms. Currently, some 65% of investigations are closed without the FCA taking any further action. Are there risks for the FCA in adopting these changes?
Well, most people think there will be really significant risks and downside to these proposals, and that includes for the FCA themselves. So, for example, currently the FCA enforcement team are able to make their investigation inquiries in full confidence, and firms are highly incentivised to cooperate with those investigations, and in many cases incentivised to settle at an early stage. So, for example, when we're supporting clients with investigations, we factor in that opportunity to manage the first public announcement of an outcome in conjunction with the FCA, and that opportunity to manage that messaging. And that factors into the strategic considerations that we go through with clients in deciding whether to settle. Now, the alternative, of course, is not to settle and pursue a case before the Regulatory Decisions Committee. And many people think that the FCA risks losing the benefit to firms of settling early, and indeed placing themselves under greater scrutiny, greater demand for speed and additional information, and will have deprived themselves of that opportunity for firms to manage that investigation message because it's already been published. And another example, I think, is the recent example of motor finance commissions, where the FCA had to take emergency action and bring in emergency rule changes to the complaints handling rules, precisely because it wanted to prevent market disruption for consumers and for firms. When the Financial Ombudsman Service published an important final decision about a motor finance commission. And so many people think it's quite surprising now that, having had to take that action, which actually older Nicole Rathie has given evidence on at the Treasury Committee in May, and described that as learning lessons from past experience and being driven by the concern about the impact on customers. But in fact, these proposals to publicise investigations early could well have a similar sort of market and customer disruption to the very problems they've tried to stop in Motor Finance Commission. So it does feel a little bit like there's some more joined up thinking that's needed on the costs and benefits of their proposed publication policy.
Absolutely. I mean, turning to the other principal regulator, the PRA has also announced changes to its enforcement strategy, in particular through the introduction of the early account scheme. How often do you think that will be used in practice?
I think most people think that the scheme has a few features which will only make it appropriate in quite narrow circumstances to be used. So a couple of those relate to timing. So, for example, where a firm decides to use the scheme and that involves commissioning an internal investigation, that investigation would have to be completed in 6 months. That's a really, that's a really fast timetable. And so that suggests it would only really be appropriate for either very straightforward self-contained cases, or, for example, cases where a lot of the work to understand the facts has already been done. For example, where there's already been a Section 166 skilled person review. And firms, the second timing point is that firms have to decide whether they want to apply for the early account scheme within 28 days of a notice of appointment being received of investigation. And so that's not very long to make that assessment, to get comfortable with the risk-benefit analysis of that sort of extra 10 to 20% discount on any fine, and indeed to give due consideration to the sort of interests of senior managers who may potentially be implicated in any investigation report. So some really tight timings that I think make it potentially quite tricky to use in practice. One thing, I think one trend we're seeing with clients, which perhaps goes to this idea of investigations being done earlier and earlier in practice before official announcements, is that clients are beginning to see a great deal of investigation style inquiry work done by the FCA at the supervision level, so prior to any referral to enforcement. And that, of course, then means that by the time enforcement get hold of a set of facts, they have an awful lot of evidence already. Now, the risk for clients, and there's real concerns around this, is that that evidence is being gathered outside of, often voluntarily and outside of some of the formal statutory protections of an investigation. And so we're calling that supervisory enforcement. And we're really urging clients to look out for it and to get that external support to make sure that the evidence that they put forward and the evidence gathering that they do and the interview or meeting answers that they give all get the benefit, the same sort of rigorous approach that they would use for an investigation.
Yeah. So basically, clients have got to be quite alert to that possibility. One of the key themes at this year's summit will be the increased regulatory interest in firms' treatment of non-financial misconduct. Given the significant increase in whistleblowers reporting misconduct to the regulator, has there been a trend towards reporting from firms on such conduct?
We're helping a lot of clients with these sorts of considerations at the moment. And of course, there's a balance to be struck, because currently the specific notification rules and the definition and guidance on what fitness and propriety means and what integrity means haven't yet changed. So the proposals from the FCA to extend that meaning into areas of non-financial misconduct don't yet have the force of law. So one of the things, for example, that we sometimes look at with clients is whether there's some benefit in having informal conversations with their supervisors under Principle 11 or Fundamental Rule 7, if it's the PRA, to enable them to bring matters of concern to the regulator's attention, but without having the formal rules in place to do that in some of the more specific notification obligations. But it's an important issue, and it's one that we'll be talking about in the panel, as you said, that I'm moderating at the conference. So we'll be looking at some of the challenges for firms being really at the coalface of trying to implement the new definitions of integrity and the intrusion into that definition including private life. Those are really some sort of subjective personal terms that the FCA use, personal judgments like morally reprehensible. And so we'll be looking at some of the constructive things that firms can think about in preparing to implement those rules.
Such a difficult grey area, isn't it? But these are all topics that we'll be exploring in much more depth at the Financial Services Investigations and Enforcement Summit in London on the 26th of June. So I very much hope that our viewers will be able to join us in person at that event. More information is available at the City and Financial Global website. Sarah, thank you so much for joining us today.
Thanks very much.